Sometimes warranties can protect third parties. The law has evolved, for instance, to protect consumers. The law has evolved to protect consumers and eliminate what was called the privity of contract requirement. So, say you buy a vehicle and you know that your vehicle has a warranty attached to it, has a guarantee for a certain amount of time. Traditionally, if there was a problem with a vehicle, your recourse was not against the manufacturer, but against the dealer who sold you the vehicle. There's a concept called privity of contract, which means in order to bring a claim for breach of contract, you must have been in a contract with this party. And so the notion was, the concept was that your claim was against the dealer. Now the dealer had its claim against the manufacturer based on its privity, but I, the consumer, could not directly sue the manufacturer. Under the privity of contract requirement, I can only sue the party I contracted with. Now this standard has been largely eliminated across the United States. So if in fact my vehicle does suffer some sort of damage, I can now go to sue the manufacturer and not simply the dealer. Sellers' warranties have been held to extend to the buyer's household members and guests. Remember, there is a contract between the buyer and the seller. Well, the warranty may extend to other people in the buyer's household or other guests of the buyer. In fact, sellers' warranties can be held to extend to any reasonable or foreseeable user. And sellers' warranties may extend to anyone injured by the good. If it was a defective good and the user was not in a contractual relationship with the seller, nevertheless the user can sue the seller for damages. Liability under a warranty can be limited, and it's difficult to disclaim a warranty, but it can be done. Now the UCC allows a seller to avoid the risk associated with warranties and disclaim warranties, whether they are express or implied. Now you should know that courts view warranty disclaimers with what we call disfavor. They don't like it. And there are federal and state statutes that make certain disclaimers unenforceable. And even if the seller can limit the remedies that a buyer can seek, it may not limit damages resulting from personal injury due to a defective product. If the product was defective and it causes harm to someone other than the buyer, the seller cannot eliminate its liability to that subsequent user. So implied warranty disclaimers are still possible. The law says the disclaimer must be brought to the customer's attention at the time the contract is formed. These disclaimers must be conspicuous, capital letters, bold print, larger than the rest of the text. Whenever you go to shop for a used vehicle, almost invariably on the window of the used vehicle there will be a notice posted. This vehicle is being sold as is, meaning there is no warranty attached to it. You have been notified that there's no warranty, and therefore the seller can disclaim the implied warranty. Sellers cannot disclaim any express warranties. If you've made a warranty, you are bound by that warranty. Now, it doesn't take a lot to disclaim an implied warranty. Things like with all faults or as is, they are sufficient to disclaim the implied warranties of fitness for a particular purpose or for non-infringement. However, to disclaim the warranty of merchantability, you must use that word. You must state that there is no warranty of merchantability for this item. Now, sellers can limit the remedies that a buyer seeks in certain circumstances. Now, we know it cannot limit damages resulting from personal injury caused by a defective product. We know that a merchantability disclaimer must specifically say merchantability. However, it is possible to disclaim an implied warranty of fitness for a particular purpose. So on your test, look for those situations that permit a seller to limit the remedies of the buyer. There are other factors that may limit liability under a warranty. A buyer's examination may limit the applicability of an implied warranty. You got a chance to examine the item before purchase, well then maybe there's no implied warranty attached. The parties can reduce the statute of limitations for a suit on warranty. If you are going to buy a garage door opener, in that contract you will see there's a limit. There's a 1-year time limit. You must bring a suit within a year. If you go past the statute of limitations, you have lost your right to bring that claim. The last thing we'll talk about, and again, this is another example of extending warranties through legislative action. These are protections aimed at consumers. I feel like we need to talk about it. I'm not going to test on this other than knowing what the act is called, but it's the Magnuson-Moss Warranty Act. And what it does is it regulates the warranties given by a seller to a consumer. The consumer is a person purchasing a good, intending to use it for personal or household use, and not for resale or for use in a business. In those situations, if there is a full warranty, it must be set out with a full warranty label that provides repair or replacement of products costing in excess of $10 and include the duration of the term. Now, limited warranty is any warranty that covers less than a full warranty. And most of the warranties that you will encounter while you're purchasing household products are in fact limited warranties. There are other provisions of the Magnuson-Moss Act that you should know. It doesn't require sellers to provide warranties to consumers, but if you do provide a written express warranty, then the transaction becomes subject to the statutory act. It doesn't create new implied warranties, but it does give to consumers the abilities to bring cases in federal court for breach of warranties that are implied by state statutes, meaning you can bring your state claim in a federal court. Written express warranties have to be written conspicuously and in plain and clear language and may not disclaim implied warranties. Whenever you purchase a consumer product, there will be some piece of paper in that product packaging, and that will often contain warranty information. The reason why this exists is because of the Magnuson-Moss Warranty Act. So in conclusion, what did we learn today? Warranties protect title to goods. There are express, implied, and statutory warranties, and the parties can limit liability under a warranty. Thanks a lot for listening. I look forward to seeing you next time.